you, ministers, for your presence in our chamber today. I'd like to go back to the question of irremediability, which is the triggering criteria for MAID. As far as I can tell, and I think you've confirmed that there is no consensus in the medical community on the irremediability of mental illness, which means each request for MAID SUMC will have to be dealt with on a case-by-case basis. Regardless of the protocols that are being developed in this period of hiatus, this effectively means that individuals with mental illness who seek MAID will gravitate to assessors who are inclined to agree that their condition is irremediable. Indeed, it is likely that all MAID assessors will be predisposed to the view that some mental illnesses are in fact irremediable because they wouldn't be assessors otherwise. My question is this: what scope is there in the law for medical professionals who have knowledge of the patient but who are not part of the MAID assessment team to intervene in a MAID request because it is, in their professional opinion, that the mental illness is in fact not irremediable?
I speak generally to the safeguard before perhaps asking Minister Duclos. In the so-called track 2, a second opinion is required from somebody not on the medical team or not giving care to the patient. So that is there as a specific safeguard, and the expert report has elaborated on that. I'm confident that, again, this will be a small number of cases requested in the grand scheme of things, and an even smaller number of cases actually accepted for MAID. But perhaps Minister Duclos would add to that.
Well, I have a list of eligibility and mechanism criteria for MAID in front of me. I summarized some of them earlier when I spoke about irreversibility, irremediability, and incurability. But the criteria are very strict, and they involve, as mentioned, that the request should not be the result of external pressure, that it has to be informed consent before and during the process, that requesters have to have a serious and incurable illness, be an advanced state of irreversible decline in capability, have enduring and intolerable physical or psychological suffering that cannot be alleviated under conditions the person considers acceptable. And then there is a strong number of safeguards for the process itself, with a number of independent doctors and nurse practitioners, complemented by others if they are not sufficiently well prepared or equipped to handle the request appropriately, with all sorts of other safeguards and mechanisms that, as you said, are there to protect the vulnerable Canadians in a manner which is under the criminal code. So this is not a light matter for assessors and practitioners.
We have 30 seconds.
What if the dissenting voice, a recognized medical professional who knows the patient, is not part of the assessment team, not even part of the second opinion that is mandatory under the rules? Does that person have any standing to intervene in the MAID request?
Quickly.
Thank you. This is all part of the fundamental criterion that to be able to have access to MAID is under very...
Je dois vous interrompre.
I must interrupt.